Assange extradition hearing, day 13, part 2, Electric Boogaloo. I'm just going to go straight back into it with the testimony of Dean Yates. And as usual, this is from Craig Murray's blog, because he is pretty much the only one who's been writing this up. Again, those of you who were kind of wondering why I'm only going with one source here, well, see if you can find me another one. I'd love to see if there's someone else who has a different point of view on this trial. But so far, Murray is it. Anyway, the United States had objected that Mr. Yates' evidence should not include description of the actual content of the collateral murder video. Yeah, I'm sure they would object to that. And this is Murray speaking, I could not hear or understand any rationale why Bereitzer agreed to this, but she did so rule, and 4 times she interrupted Edward Fitzgerald QC that while he was reading the gist of Yates' statement, to tell him he must not mention the content of the video. Now, Murray puts the word gist in quotes. That says to me that this is the word the judge is using. They're actually using gist to refer. We're just getting the gist of the evidence. Yeah, I don't think that's how courts of law are supposed to work. I mean, I know the full statement has been entered into evidence, and I know that Judge Bereitzer has said that she's going to read the whole thing and take it all into consideration when she makes her ruling, but geez, come on. At least pretend to be public about it. Alright, so anyway, Yates was bureau chief for Reuters in Baghdad. Early on 12 July 2007, loud wailing broke out in their office, and he learned that Namir, a photographer, and Saeed, a driver, had been killed. Namir had left early to cover a reported conflict with militants. Yates could not work out what happened. A minivan nearby had its front shattered. The military had taken Namir's 2 cameras and refused to release them. The report was 13 killed and 9 injured. There did not appear to be any evidence of a firefight at the scene. He was told that a hostile group had been deploying improvised explosive devices in the road. He was shown photographs of machine guns and RPGs allegedly collected from the scene. He was shown 3 minutes of video. It showed... Here, Bereitzer cut Fitzgerald off. Yates had subsequently submitted a request to the U.S. military to view the whole video, which had been denied, so had requests for the rules of engagement. When WikiLeaks released the collateral murder video, in the video Saeed was shown for 3 minutes crawling and trying to get up, while the Americans watching him remotely were saying, "Come on, buddy, all you gotta do is pick up a weapon," so they could shoot him again. The Good Samaritan pulled up to help, and the shots were seen destroying his windscreen and car. Edward Fitzgerald kept doggedly reading out bits of Yates' testimony as Bereitzer continually asked him to stop in a manner that was almost pleading. So it really sounds like she's continuing her emotional state from earlier in the day. Like she just really doesn't want to hear this. But I mean, she's going to have to review all of this, including the video, when she goes back to consider her ruling. So, I don't know, we'll see. But maybe Bereitzer is a Dalek no more. I have to admit, I didn't see that coming. Yates said that when he saw the video, he immediately realized the U.S. had lied to them about what had happened. He also immediately wondered how much of that meeting at U.S. HQ had been choreographed. He had always blamed Namir for peeking around the corner with his camera, which had been mistaken for a weapon and therefore caused him to be shot. It was Julian Assange who subsequently made the point that the order to kill Namir had been given before he had peered around the corner. Yates was glad to absolve Namir, but felt a terrible burden of guilt for having blamed him all the while for his own death. Yates concluded that had it not been for Chelsea Manning and Julian Assange, the truth of what had happened to Namir and Saeed would never have been known. Thanks to WikiLeaks, their deaths had a profound effect on public opinion. James Lewis QC stated the American government had no questions, but this did not imply the evidence was accepted. Alright, exit James Lewis, enter Claire Dobbins with the sequel to her examination of Carrie Shankman. Remember, she had started that before and then they had postponed, so we're picking back up on this. He was testifying on the history of the Espionage Act, and Murray says, this may seem dull, but it has actually been extremely revealing in terms of revealing U.S. government claims of the right to use the Espionage Act of 1917 against any journalist anywhere in the world who obtains U.S. classified information. Remember, they're no longer saying it's just about Assange and Assange is not a journalist. They've come right out and said, any journalist anywhere, they can do this too. And Shankman said there had never been such a prosecution, so it had never come before the Supreme Court. Dobbin asked whether he accepted that in the New York Times case, the Supreme Court had said that such an Espionage Act case could be brought. Dobbin replied that some of the judges had mentioned the possibility in their dicta, but that is not what they were ruling on, and they had not heard any arguments before them on the issue. Dobbin said that the judge in the Rosen case had stated that the New York Times case might have had a different outcome if pursued under the Espionage Act. Shankman said the Rosen judgment was an outlier and did not refer to media publication. The Justice Department had decided no further action on Rosen. Shankman referred her to a 2007 Harvard Law Review article on Rosen. It had been dropped because of First Amendment concerns. Dobbin tried again and asked Shankman whether he accepted that the judgment in Rosen found the interpretation of dicta in the New York Post case did not preclude prosecution. Shankman, who seemed to be enjoying this, said the issue had not been briefed before the Supreme Court, and the Rosen judgment had not been carried through. The Supreme Court can't just do whatever they want. They can't just look at something and say, hey, that's bad, we're going to rule on it and strike it down. You have to have a case actually come before them. And there's a whole process to get to that, involving starting with the district court, up through the appellate court, and then after that, if you want to appeal, even before it's heard by the Supreme Court, you have to get the writ of certiorari, and they almost always deny cert, so really difficult to get a case before the Supreme Court. Most of them never make it. Dobbin then suggested the prosecution could not be political because it was the court that decides the definition of national security information. Shankman replied that on the other hand, it is the executive that decides what material is classified, who is prosecuted, and on what charges. It was not just a matter of prosecution. The Espionage Act could be shown historically to have a chilling effect on important journalism. There had been numerous successful prosecutions of whistleblowers under Obama. Plainly, the courts generally accepted that these provisions applied to government insiders. There had never been a prosecution of a journalist or publisher. So Dobbin put to Shankman the fact that numerous potential prosecutions had been dropped just proved the act was used responsibly and properly. Shankman said that was to ignore the chilling effect both in general and in specific threats to prosecute. Chilling caused papers costs, delays, and even bankruptcies. President Roosevelt had used the threat of the Espionage Act to suppress independent black newspapers. Yes, that was FDR, Mr. Progressive himself. It really happened, look it up. But Dobbin said that none of the past examples resembles WikiLeaks. Shankman again disagreed. There were many striking points of similarity in different cases. Dobbin replied that WikiLeaks' sole purpose and design was to source material from those entitled to receive it and give it to those not entitled to see it. It was solicitation on a mass scale. Shankman said she was reaching for a distinction. Similarities to the Beacon Press and Amerasia cases were obvious. Dobbin concluded that Shankman's opinions and evidence was frivolous and nonsensical. Man, again, I don't know about British courts, but these are prosecutors from the U.S. That kind of behavior from a prosecutor would never be tolerated by a judge in a U.S. court. Actual name-calling, your evidence is frivolous and nonsensical. No, they wouldn't put up with that. You're supposed to be examining the witness. Save your arguments for later. Mark Summers then re-examined Shankman. Summers referred to sentences from judgments which Dobbin had invited Shankman to accept as uncontrovertible statements of the law, but which were anything but. In the Morrison case, he pointed out that the two other judges in the case had explicitly contradicted the very sentence Dobbin had quoted. Judge Wilkerson had stated, "The First Amendment interest in informed national debate does not simply vanish at the mention of the words national security." Summers said above all, the U.S. government now relied on the Rosen judgment. He asked what level of court that had been. Shankman replied that it was a district court, the lowest level of U.S. court, and the Justice Department had decided against proceeding with it. Finally, Summers said that Shankman had stated there had never been a prosecution, but there had been threats, resulting in a chilling effect. What types of people had been threatened with prosecution under the Espionage Act for publishing? Shankman stated that in every case it was political. Opponents of the presidency, minority groups, pacifists, and dissidents. And Murray, in his kind of summary of everything, points out that the government of the United States had objected to almost all of the defense evidence. They want the defense witnesses ruled as either not expert, hence the sustained rudeness and attacks, or not relevant. Judge Bereitzer had ruled that she will hear all the evidence and decide only when she comes to judgment what is and is not admissible. We then have her decision that the witnesses can only have half an hour of going through their statements before cross-examination. That is against a U.S. government request that witness statements should be heard before cross-examination at all. Bereitzer rejected the defense arguments that statements should be read or explained at length by the witness in court for the benefit of the public on the basis that the statements are published. But they are not published. The court does not publish them. It gives copies to journalists registered to cover the trial, but those journalists have no interest in publishing them. And again, if anyone knows where they are, Murray gives a link, but when I actually try to go to the actual reports, the actual witness statements, I get 404 errors and all sorts of other things. So please, if anyone knows where I can find them, even if it's the Pirate Bay or somewhere like that, let me know. I'll download them. I'll put them on my website. I'll host them. I don't care. I ain't in England. Their law's got nothing to do with me. Their courts can't touch me. All right, next we have the specific pieces of evidence that are banned on U.S. objection, like the details of El-Masri's torture or of the content of the collateral murder video. I can understand that it is true that this court is not judging if El-Masri was tortured. In fact, that is now established by the ECHR. But plainly, this story is relevant to WikiLeaks' defense of necessary publication to prevent crime and enable judicial process. The fact is that the USA wants to avoid the political embarrassment and media publicity of El-Masri's torture and the events of the collateral murder video being detailed in court. Why an English court is complying in this censorship is beyond me. I am deeply suspicious of the breakdown of the video link. I am also deeply suspicious of the strange fact that unlike other witnesses with video problems, there was no rescheduling. Video and sound quality has been deplorable for several defense witnesses. In a world where we have all got used to video calls this last few months, this extraordinary failure of the court to operate everyday technology is a level of incompetence it is difficult quite to believe in. Lewis consistently and repeatedly quotes the words of Luke Harding and David Lee to witnesses more or less every day, yet Lee and Harding are not in the witness box to be cross-examined on their words. I am absolutely furious that Lewis has been allowed to repeat Harding's words about the conversation in the El Moro restaurant to witness after witness, but that John Getz, who was actually part of the conversation and an eyewitness, was not permitted by the court to testify on the subject. That is absolutely ludicrous. Finally, we have the affidavits submitted by Kromberg and Dwyer on behalf of the U.S. government. These are apparently treated as evidence. Lewis specifically categorized Dwyer's proof-free assertion in Dwyer's affidavit that informants had been harmed as evidence this had happened. But how can these affidavits be evidence if the authors cannot be cross-examined on them? It is not right that an affidavit full of highly dodgy statements and propositions should be accepted as evidence if the author cannot be challenged. The prosecution has repeatedly claimed that the 134,000 unclassified and or redacted cables in the original limited mass cable released by WikiLeaks included names marked Strictly Protect. And Murray confirms what I've been saying, this is not a security classification. As someone who operated the near-identical UK system for over 20 years and held the very highest levels of security clearance and frequently in that period read American material, let me explain to you. Any material which contained the name of someone who would be at risk of death if published, or which would create real and acute danger to the national interest, would, by very definition, have been classified secret or top secret, the latter generally relating to intelligence material. All of the Chelsea Manning material was at a level of classification below that. There exists, separately to the classification, a distribution system which limits who actually gets the material. The Manning material was unlimited in distribution and therefore available literally to tens of thousands of people. That, again, could not have happened if it contained the dangers now claimed. Strictly protect is nothing to do with security classification, which is what protects national security information. As Hager said, its normal use is to prevent political embarrassment. Yeah, this has nothing to do with the safety of informants or anything like that. The U.S. government was embarrassed. More than that, they were shown to be criminal thugs. And that's what they don't like. So, again, I'm unaware of any of these murderers that were exposed by Assange as serving out life in prison, as any other murderer would be. But Assange, gotta go after. I don't know. We'll see what happens on day 14. Hopefully, Judge Bereitzer, the former Judge Dalek, is having more of a realization about what she's been doing this whole time. And maybe, just maybe, she'll move more towards the side of justice and truth. Call me naive, call me an optimist, but I have to at least hope. But we'll see what happens on this upcoming week. Thank you so very much for listening. As always, please spread this everywhere you can. This is a video on YouTube. It's audio files that I've uploaded to BitTube and other places. Spread these around everywhere. Spread Murray's blog around everywhere. Get the word out about this. Talk about it to family and friends. Say, hey, did you know this was going on? Do you know anyone who's like a journalist, like a local reporter or something? It's like, hey, have you been told about this? Because this is really important. And make sure you hit like, subscribe, and the bell so that you get the rest of these when I post them. And other videos I have that I hope you'll enjoy. And if you really like what I'm doing, please consider going to donate.bogosity.tv and giving at least a few pennies. Or you can become a regular subscriber at Patreon and Subscribestar. I kind of dumped these to my regular subscribers over the weekend, so they kind of got all of these in one go. So you can always get this pretty much as soon as I get them recorded and edited. Just $1 a month will do that, Patreon or Subscribestar. But above all, please keep watching. Thank you so very much. We'll be back for day 14. Until then, stay strong and be free.